May please, your lordship. Lordship, I have to mention for listing of a petition lordship. It is a 2013 matter. The matter is just for correction of the date of birth of the petitioner in the service record and provide the necessary service benefits.
2013 last listed.
2013.
You must be
No,
required.
lordship. It was last listed on 5/12/2022, lordship.
So you want it day after tomorrow, most probably,
Lordship, as your lordship.
after vacation. Yes.
After vacation only, Lord.
After vacation.
May I please, your lordship? Your lordship, I beg to mention item number 24 of today's list.
Yes.
That the matter may be adjourned for today, your lordship, and with the consent of the other side, your lordship.
With the consent of the other side, Mr. M. Sharma, learned counsel for the respondent, blank seeks adjournment of admission hearing of this matter. With a request to post this case again after the summer vacation. Since the prayer is not opposed, same stands allowed, list accordingly.
Another item number 23, your lordship. That if allowed, this item may be taken at 2, your lordship.
Those things cannot be guaranteed. We'll see as the matter proceeds.
Yes, your lordship.
We'll see. Yes, sir.
May
If the
please-
item reaches, I will,
Yes, sir.
Hi.
Why at two? Why?
your lordship, that I have some matter. So
Where? You have some matter where?
it's court number 1, your lordship.
Finish it off and come.
Yes, sir.
Yes.
May please, your lordship. With the consent of the other side, I beg to mention item number 42 and 43. My senior is suffering for fever.
What do
Kindly
you want?
matter adjourn for today,
Item number
42 and 43.
contempt cases.
Yes, lordship.
You wait, you be there, we'll see. Let us see what order is to be passed. You remain present.
Okay,
All
lordship.
right.
May it please your lordship, with the consent of the other side, I beg to mention item number 51. Lordship, the state have filed their affidavit. We seek 1 week time to file our reply. Lordship, also the matter we taken up with the similar matter, writ petition number 3314 of 2023. It's listed on 26th of June.
Ms. P. Gupta, learned counsel appearing for the writ petitioner, submits that a copy of the counter affidavit filed on behalf of the respondent number.
Respondent number,
Yes.
yeah, respondent number 2,
Yes,
Lordship.
Respondent number
2.
2 has
Yes,
been
sir.
served upon her,
2, lordship.
and therefore a week's time be given to file rejoinder. Full stop. The learned counsel for the petitioner also seeks posting of this matter along with WPC number 3314 of 2023, which is fixed on 26th of June 2023. The prayer is not opposed by Mr. P. Nayak and Ms. M.D. Bora, learned counsel representing the respondents. In view of the above, this matter stands adjourned till 26/6/2023. In view of the above, on the prayer of the petitioners counsel, this matter stands adjourned till 26/6/2023. List along with WPC number 3314 of 2023.
Much obliged.
My lord, the matter became old because a review was filed and review recently allowed. My lord, I have, in this case, my lord, I have challenged an order passed by the banking ombudsman, my lord, by which the
This petition is filed, this petitioner was Anil Sharma.
lordship.
Is he alive?
No, he is not, but he is substituted by his.
But not in the writ petition.
But there is a substitution was allowed, my lord.
There is no substitution in the writ petition.
Huh?
Check it, check it.
Miss case was filed and it was allowed, my lord.
Where is the miscase? What is the miscase number?
Miss case number 2. Hold on, this is the- Huh? Miss case number. Huh? That's it? allowed data the- data. My lord, the miss case was allowed on by the order dated 28th of February 2018.
What is the miss case
And
number?
by this, by your lordship, miss case number tonight. The number is not here, but it was, well, I think, my lord, you can check it out.
Check it out, we'll take after some time,
Lord.
at 12, yes.
Lord.
If there is no substitution, then it is abated.
That's
So
it.
you will have to file a petition for setting aside abatement. By granting that
but-
liberty, we'll close the matter.
But it was, my lord, we have filed.
If it is there, then it is there.
Lord.
But in any case, what is there in this matter now?
My lord, in fact, my lord, the banking ombudsman has, without hearing, without giving opportunity, but I have purchased a, my lord, term deposit.
Hmm.
And the condition was that I'll present this before the bank and then they will make the payment. But year by year, that was reduced by my lord. Suddenly, when I inquired, they said that it is not traceable. The amount, they could not trace it. Sometimes thereafter, my lord, they have said your entire amount is deposited in the savings bank account.
Hmm.
I have not given any instruction. My original term deposit receipt is with me. They cannot do it. Then I wrote them that give me the particulars, show me the account, everything by which you said the amount deposited is relatable to the my deposit. They have not given anything. And the respondent bank also appeared number of occasions. Did not file anything. Thereafter stopped appearing. Therefore, again I have to take steps. And then the notice was served to them. They did not appear. They have no records to show that the amount has been deposited in my
So
account. That's,
what is the prayer you are making today?
but to make payment of the, or at least but show me the details,
That cannot be done in a.
or at least but make payment. Because why not? Because the lordship is indicating that it's a private bank, my lord.
Yes.
Otherwise, my lord, there is a loss, my lord. The Supreme Court has recent decision also out there.
No, the ombudsman says the amount was deposited, you never checked your account.
Ombudsman said, ombudsman has not given me an opportunity. Let the ombudsman give me an opportunity to hear it. That is the prayer, my lord. And because the scheme says he must issue notice to me, to the bank. And
Right, you first show how the substitution is happened,
Lots of-
otherwise it has to be closed as abated.
lots.
You will have to file petition for setting aside.
That's it.
May please, Your Lord.
Yes,
At this stage, my lord, in my case, my lord, only notice will suffice, my lord. Whatever the judgment of this honorable court in readable number 45 of 2024, my lord. We are also entitled the same benefit granted by the judgment, but that was denied to us.
which judgment you are referring to?
There is the readable, my lord, 45 of 14, my lord. I have copy of the judgment, my lord. I am supplying it.
That is Upendas.
Here.
Upendas.
Yes. At this stage, notice may go to my lord.
I heard Mr. S. Kotagil and counsel for the petitioner. The read petitioners, 45 in total, have approved this court internally alleging that although they has served for a continuous period of more than 10 years under the respondents as casual workers, the benefit of the judgment passed in the case of Upendas and others versus State of Assam and others in the REIT appeal number 45/2014 has been illegally denied to them. Ms. A. Bora, Learned Standing Council, Health and Family Welfare Department, Assam, prays for some time to obtain instruction.
1 and 2, Lordship. I am for 1 and 2.
Respond numbers 1 and 2 prays for some time to obtain instruction in the matter. Issue notice returnable in 6 weeks. Since Ms. Bora has accepted notice for respond numbers 1 and 2 and Ms. R.B. Bora, Learned SC BTC has appeared for respond numbers 3 and 4. No formal notice is required to be sent in this case. Extra copies of the writ petition and requisite in numbers be served upon the respondents' counsel. List this case again by reflecting the name of Learned Standing Council representing the respondents.
Ma.
Lordship, here in this matter on the previous occasion, Lordship wanted to know the PWD status of the petitioner, Lordship. Lordship, the petitioner was found visually impairment with 30%, Lordship, not 40%. Lordship, I have the report, Lordship.
No, that's not the point. Point is, why was he asked to appear before the medical board? That's his grievance.
Lordship, because on secondary, Lordship, on secondary education departments, Lordship, because since this certificate was of 2018, Lordship, and the version low vision is only of 40%, that's why, Lordship, they were asked to appear. All the candidates, Lordship, they appeared on 18/5, and then this examination was held, and then the results are here, Lordship.
So he has already appeared.
Yes, Lordship, on 18/5 he appeared, and his reports are here, Lordship.
What does the report say about? petitioner?
30%, Lordship. I have the.
My lord, kindly see page 24, my lord. Annexure D. The UDID card, my lord, issued on 24/2021. As
So,
per
Mr.
the-
Chauhan, what are you actually trying to canvass now? They found it was 30%. Your certificate says it is 40%. The read code will not decide whether it's 30% or 40%. What is the relief you are seeking?
Appointment, my lord.
Appointment.
Praying for an appointment.
Read
Yes,
code will give you appointment.
yes, ma'am. I have been already selected, my lord.
Heard Mr. R.S. Chauhan, Learned Counsel for the petitioner, also heard Mr. B.
For 2, 5, and 6.
Standing Counsel Health and Family Welfare Department, Assam appearing for response numbers 2, 5, and 6. Miss H. Directly, Learned
For
Counsel-
1 and 4,
Learned Standing Counsel,
Secondary.
secondary department.
Secondary Education Department, Assam, as appeared for response
state
number
level.
1 and 4. Mr. Upamanu submits that although the disability or visual disability of the petitioner was earlier certified in the year 2018 as 40%, yet pursuant to a re-verification by the medical board, it was found to be 30%,
Yes.
which is less than the required degree of disability under the statute. Mr. Chauhan has, however, denied the said fact and submits that his client is entitled to appointment as a candidate coming within the PWD category. First up, since the core issue raised in the writ petition pertains to a disputed question of fact which cannot be adjudicated in a writ petition. Hence, taking note of the grievance expressed by the petitioner, this writ petition stands disposed of at this stage of motion hearing with a direction upon who is the authority, director,
Lordship, this is the secondary education, Lordship.
Director of Secondary Education, Assam. That is the response number
4.
to examine the issue and pass appropriate order therein after ascertaining the degree of disability of the petitioner. If the petitioner continues to remain aggrieved even thereafter, now the exercise be completed within 4 weeks from today. 4 weeks from the date of receipt of a certified copy of this order. If the petitioner continues to remain aggrieved in the matter, no, before that is right. If it is on such verification, if it is found that the petitioner's disability conforms to the statutory requirement, then in that event, he shall not be wrongfully denied appointment. With the above exercise be carried out and completed within 4 weeks from the date of receipt of a certified copy of this order. With the above observation, writ petition stands disposed.
Lordship, instructions produced. Lordship, the instruction produced.
Instruction produced by the Learned Standing Council Health is retained in the record. Yes.
Highly obliged.
Obliged.
May I please, your lordship, here the petitioner has appeared interview for selection as the translator in Hindi, my lord. He has secured second position, my lord, and first one, both are OBC, but first one has been considered as per this honorable court, my lord. The case earlier, in the earlier litigation, the court has considered that the first one to be considered for general. So second one, my lord, it should be, I may be accommodate to that. But not only that the height, required height is 170 centimeter, but I have 169 centimeter. Then the one of the provision is there. Circular is that relative of the any Assam Rifle personnel. Then my elder brother is also working the Assam personnel. In that way, I have been issued with the certificate that I should be relaxed of that 2 centimeters, they can relax, my lord, as per office memorandum, my lord.
What is your instruction, Mr. Goswami?
This is the first is coming.
This is the first time.
Next week, I will post it for motion, we obtain instruction. Whether he is entitled to relaxation,
Can it be after vacation? My lord?
then you don't make, you keep one post vacant then. Then you will keep.
Well,
one
is
post
a
vacant.
selection process initiated in 2017, my lord?
Why don't you get the preliminary instruction?
Well, I'll try, my lord, definitely. my lord.
Otherwise, he'll ask for interim
Well,
slip, we'll have
well.
to consider. Or Mr. B. Sinha, learned counsel for the petitioner. As per the case projected in the writ petition, the petitioner was wrongfully denied selection stroke appointment as Hindi translator under the,
No.
what is the UP cadre?
Yes, my lord. Yes. UP cadre, my lord.
UP means Uttar Pradesh.
Yes, Uttar Pradesh, my lord. The Uttar Pradesh selection, the Uttar Pradesh candidate, their height is required, height is 1.70 meter. My lord. Therefore, I am 1.69.
So you are seeking appointment in Uttar Pradesh?
No, here.
He is originally from Agra.
I am
That is
from-
why he is a native of Uttar Pradesh. And for the people who are residing in.
But selection, I have appeared here, man.
Hindi translator on the ground that he does not. What has height got to do with the Hindi translator?
Well, to one.
What has height got to do as a Hindi translator?
170 centimeter. my lord.
What is it relevant? People who have 170.
Well, that is a rule, my lord.
But what is the logic behind this rule?
My lord, what happened, my lord, the peoples of the
If
Uttar
people less
Pradesh and
than
other part of the
170
country is.
Listen.
My lord,
People less than 170 centimeter can become high court judges.
my lord.
They can't become Hindi translators. What is the logic behind it?
My lord, my lord,
There is no logic.
there is a logic, my lord.
What is the logic?
Definitely, I am satisfied, Lord. Your Lord is fix the matter.
Wrongfully denied selection of the appointment for the post of Hindi translator on the ground that he does not fulfill the minimum height requirement of 170 cm. However, Mr. Sinha submits that since the petitioner's elder brother is already serving in the under the Assam Rifles, he was entitled to relaxation of 2 centimeters, in which event the petitioner would meet the eligibility norms. First of Mr. Goswami, Learned UK Goswami, Learned CBC, is for posting this matter again on 25th of June 26th of June 2023, so as to enable him to seek preliminary instruction and respond to the allegation. Prayer allows one extra copy of the repetition. This matter be posted again on 26/6/2023.
May I please, your lordship? The petitioners were engaged as casual workers, lordship, in hospital management committee, where they are still working
These are
from more
covered
than 12
cases.
years. The
Covered
covered
cases.
case.
No, my lord, here, so far as the Upendra's case is concerned, my lord. There, my lord, the condition is, my lord, they will have to work for 10 years till the date of passing of Upendra's case. Here, all the, my lord, petitioners have been engaged after 2007. So 10 years will not come in, my lord.
2007.
Yes, at least June 2007, my lord, prior to June 2007.
2007 to today is not 10 years.
No, my lord. The Upendra judgment says, my lord, it will be 10 years till the date of passing of the judgment, my lord.
Is it mentioned there?
It says so.
Where is it? Which paragraph? Where does it say that 10 years will be reckoned up to the date of passing the judgment?
Otherwise, my lord, it will be a
No,
qualifying service, my lord.
you can't
Everybody
add-
will my lord, come in as casual worker. Then,
Cannot add words to the judgment of this court.
my lord,
You know the law. Judgments have to be interpreted literally, not purposively.
lordship, may I-
Where is the expression?
my lord, para 22. And the other part, my lord, they are not casual workers, my lord. Lordship may kindly see their appointments. Oh, it has been understood.
Yes, which part you are?
Para
referring-
22, my lord. My lord, it starts, my lord, we accordingly. The 7th, 8th line. We accordingly
directed state government to implement the measures without further. Besides this, we, in the light of decision of Supreme Court in State of Punjab versus Jagdish Singh, 2017 1 SCC 148, also direct the state government to pay minimum of the pay scale to the masteral workers, worksters workers, and similarly placed employees working since last more than 10 years, not in sanctioned posts, with effect from 1/8/2017.
So they are 2007
My lord.
and this is 2017.
No, they are from my lord 9, 10, 11, like that. my lord.
That's
They-
correct. So working since last more than 10 years with effect from 1/8/2017.
My lord.
What does it mean? This apparently there is some error in the order, but you have said quite, you didn't ask for correction.
My lord,
2017, 10 years will be 2027.
in that case, my lord, all will be engaged on casual basis by the various departments, then qualifying will be 10 years. You work for 2000 now, thereafter you get the minimum of the pay scale.
No, that was the idea of the
My
judgment.
lord, that probably, but
In
then notice,
lieu of
no,
regularization,
my lord,
you examine their individual cases in the light of the judgment and pass appropriate orders. What is there for the Read Court to do here?
lordship, otherwise, my lord, lordship may kindly for a moment the engagement letters, my lord. These are not engagement letters, these are certificate issued by some officials on individual capacity, my lord. They have not annexed anything,
That
my
is
lord.
correct, but
And the other part, my lord, may I submit, these are all engagement made by the health management committees, not by the government, my lord. And the
Alright,
committee is
now,
not a
Mr.
party
Relating-
responsible.
your name, please.
Yes, sorry, Lordship, may I
As the
Lordship,
learned counsel for the
The
petitioner.
committee is not a
agreed
party. in
by
the-
non-consideration of their case for payment of minimum wages as per the mandate of the judgment and order passed in the case of Upen Das versus judgment passed in the case of State of Assam versus Upen Das in writ appeal number
45 of 2014.
45 of 2014. Yeah, I got to change for you. The instant petition has been filed seeking writ of mandamus. Mr. Gogoi, Mr. B. Gogoi, Leonard SC.
Health
Health Department Assam submit that the petitioners are not eligible for consideration under the judgment rendered in the case of Upen Das Supra. The Learned Department Council, however, seeks time to file affidavit. Prayer allowed, NOM 66, since Mr. Gogoi has appeared and accepted notice.
My lord, here I appear for all the respondents. But the, my lord,
All the respondents, etc. Can do your position.
may I please? your
and one
Lordship?
more, my lord, the
May I-
management committee, my lord, who has appointed or engaged the petitioner is not a party respondent. in the
You
petition.
take that.
My lord, we'll take that.
May I please? There's a covered case already. The matter relating to the husband and committee has already been settled.
All right, all right.
Lordship.
May I please refer?
Yes.
A matter relating to promotion, my lord, Naik to Havildar, my lord.
Hmm.
In this case, my lord, past 25, my lord.
Hmm.
Promotional cadre training course, my lord, where the names of the petitioners appear. And thereafter, my lord, petitioner complete the training course, successfully passed the training course, my lord. Page 32, my lord.
Hmm. Their case has not been considered.
My lord, there is a approximate 100 post of Havildar is blank vacant, my lord, as on today, my lord. To the information, my lord.
Let them open, Mr.
Yes, my lord.
Add this, my lord. Notice.
Or Mr. A. Martin, Learned Counsel appearing with the petitioner. The read petitioners agree due to non-consider, the read petitioners herein are all working as NAYACs
Yes,
under the
AISF.
AI,
AISF, Assam Industrial Security Force.
AISF. Full stop. Agreed by non-consideration of their cases for promotion to the next higher post of Havildar.
Havildar.
The instant read petition has been filed seeking a writ of mandamus. Full stop. Mr. T.C. Chutial and additional senior government advocate Assam
All the
appearing for the respondents prays for 6 weeks time to obtain instruction filed. Prayer allowed, and on 6 weeks, that was a
We'll provide extra copy. my lord.
extra copies.
In this matter, my lord, the issue before your lordship is whether the petitioners would fall under the 1969 pension rules or the new contributory pension scheme. We had approached this honorable court earlier, recording a prima facie satisfaction that we would fall under 69 rules. In spite of that, it was remanded back to the authorities. Now the authorities have passed on order rejecting our claim. That is what is under challenge. Your lordship will issue notice at this stage.
Heard Mr. Al Chaudhary, and senior counsel by Mr. S. Biswakarma, and counsel appearing for the petitioner. The controversy raised in this petition is pertinent to the question as to whether the petitioner would be covered by the old pension rule or would he come within the purview of the NPS introduced in the year 2005.
With effect from 1 to 2005, it says, we are appointed prior to that.
With effect from 1 to 2005. I have perused the amendments made in the petition. Mr. K.P. Pathak, learned SC.
PDCL.
Appearing for the.
Respond numbers 2 and 3.
3 prays for some time to obtain instruction in the matter. NOM 6 weeks since Mrs. Borua, learned Government Advocate Assam, will accepted notice for respond number 1 and Mr. Pathak for respond numbers 2 and 3. Service of notice is complete, etc. Extra purpose.
Right.
May I please your lordship? The lordship, the matter pertains to compassionate appointment, my lord. The grievance of the petitioner is that his proposal for compassionate appointment was rejected on the ground that his application was submitted after 4 months and 11 days from the date of death of his father, my lord. His father died on 18/1/2009. Yes, my lord.
2009.
9, my lord. My lord, he applied on to 29/5/2009.
That is 14 years back.
14 years back, my lord.
14 years.
No compassionate appointment can be granted today.
My lord, the fact of rejection of his application was not communicated. Only after filing an RTA application, he got that information, my lord. That is why there is a delay, my lord.
Where is the resolution?
Page 27, my lord. Page 27, paragraph 7.
But we'll keep it pending because what about the cases where due to your failure, time has been useful time, crucial
But-
time has been lost.
My lord, in this case, the DLC has considered his case in the year 2009, my lord. It is decided, considered in 3/12/2009. And the petitioner has submitted his application after the expiry period, my lord.
What is
This is 3 months. This is 3 months. At that time, lordship, the 2nd March 2009 OM is relevant. 2nd March 2009. And as per the clause number 1, application for appointment under the scheme is prescribed format should be submitted within a period of 3 months. The lordship, here lordship, I am relying my lord judgment, Pranjal Coast. Lordship is similar cases dismissed.
So what has happened? He submitted application after 4 months and
11 days, my lord.
11 days.
but as per the OM, it should be within
3
3 months.
months. 3 months.
What did the DLC do?
Deals, he has submitted his application lately, my lord.
My lord, later on in the Fazil Nessa case,
One by one.
my lord.
Then what did the DLC do?
DLC has rejected, considered but rejected. Lordship may kindly have a look, paragraph 7, my lord. His name, the proposal number 25 from the 3rd line, my lord. Proposal number 25 of Sri Sanjay Deka, son of so-and-so, was rejected as the application was submitted 4 months, 11 days after the death of the person, my lord. He has lately submitted the application. It is not the fault of
And
the
today
DLC.
he is challenging this 3/12/2009 in this writ petition.
In my lord. After 14 years, 5 months, we cannot.
My lord, later on in the Fazil Nessa case, time limit was extended to 1 year, my lord, because this is not always possible for an applicant to submit within 3 months, my lord, due to various conditions, my lord, because a person has to prepare various documents after the death of his employee.
But this decision is of 2009. Today, how can we set it aside? We cannot set it aside. You understand it. Heard Mr.
Yes, Vikas.
Yes, because the counsel for the commissioner. Also heard Miss M.D. Bora.
I am for 1 and 4, my lord.
Government Advocate Assam appearing for respondent number 1 and 4. Mr. RM Das.
I-
Learned-
1, 2, 3, and 4. Lordship.
I'm five, 1 and 5, madam.
It's a one and
No,
five.
it's wrongly listed.
Yes, yes.
Wrong.
Mr. RM Das, Learned Standing Council, WR Department, has appeared for response numbers 2, 3, and 4. The father of the writ petitioner had died in harness on 18/1/2009. First up. After 4 months and 11 days from the death of his father, the petitioner had submitted an application on 29/5/2009 seeking appointment on compassionate ground. First up. At the relevant point of time, the time limit for submitting such an application was up to the period of 3 months from the date of death of the government employee. First up. Since the application was filed beyond the prescribed time limit, the district level committee of DLC, district level committee of Nalbari, in its meeting held on 3/12/2009, had considered the application of the petitioner and rejected the same on the ground that the application was submitted beyond the prescribed time limit as laid down by the government OM. First up. It is this resolution dated 3/12/2009 which has been put under challenge by filing the instant writ petition after a delay of 14 years. First up. The learned counsel for the petitioner has advanced 2 arguments. Firstly, that there were unsurmountable difficulties on the part of his client to submit the application within the prescribed period of 3 months. Therefore, this period ought to have been condoned. Secondly, that in the decision rendered in the case of
Fazilan Nesaman.
Fazilan Nessa, do you have the citation? His court has held that the application is required to be filed within a period of 1 year. Give me the citation, give me the citation. Hence this writ petition. It is also a submission of Mr. Vikas that his client was not aware of the outcome of his application until recently. Ms. M.D. Bora, learned Assam, on the other hand, has relied upon the order dated 15/5/2023 passed by this court in WPC number 2349/2023, bracket Pranjal Conch, KONCH Conch versus State of Assam and others, to submit that. Applications for compassionate appointment cannot be entertained nearly 15 years after the date of demise of the applicant. Full stop. Similar is the stand of Mr. Das, learned departmental counsel, appearing for the Water Resources Department. Full stop. The fact of the matter is that the father of the petitioner had died nearly more than 14 years back. Full stop. And his application was rejected on 3/12/2009. Full stop. The ground on which the application was rejected cannot be called as arbitrary, since as per the prescribed norms holding the field at the relevant point of time, all applications were required to be filed within a period of 3 months. Full stop. Be that as it may, the larger question that would arise in this case is that can the petitioner be directed to be appointed on compassionate ground after 14 years of the demise of his father? Full stop. The answer to the question has to be in the negative. Full stop. This court has time and again observed that the scheme for appointment on compassionate ground had been framed by the government to give immediate relief to the family member of the deceased employee who was the sole bread earner. Full stop. If the petitioner could survive for more than 14 years, and that too without making any inquiry as to the fate of his application at the relevant point of time, this is sufficient indication of the fact that he had other means to sustain Full stop. In other words, the element of compassion in this case appears to have been completely lost, so as to bring the application of this petition of the petitioner within the ambit of the scheme framed by the government of Assam. First off, situated thus, I am of the view that there is no merit in this petition. The same is accordingly closed.
Deeply obliged. Lordship, the citation is 2010 4ZLT 340. I'm deeply obliged, my lord.
May I please your lordship? This also matter related to the compulsory appointment. My lord, here rejection ground page 43. The page 43, the rejection ground by SLC, that DLC has placed the petition after 5 years. Not my fault. I have applied within the time, everything is there. Once they have sent it to wrong forum, it has come back. I have again come to High Court.
That will examine, because if the delays.
Similar matters are
Similar
fixed.
matter
in
are
the
fixed.
earlier-
Yes. I heard Mr. S. C. Biswal and counsel for the petitioner agreed by rejection of her prayer, his prayer for appointment on compassionate ground. The instant writ petition has been filed. Mr. Biswal submits that the delay in consideration of the application submitted by the petitioner occurred due to lapses on the part of the DLC, for which the petitioner cannot be held responsible. The learned counsel for the petitioner further submits that similar matters are fixed for hearing before this court, and therefore this case be also tied together. This S. Burwa, learned government advocate Assam, has appeared on behalf of respondent numbers. Respondent numbers,
I am 2 and 4.
respondent numbers 2 and 4, and submit that this matter be taken up along with WPC number
5086/22.
5086/22 in the batch of connected petition. Mr. S. Dutta, learned standing counsel PNRD. is
1,
present
3 and 5.
on behalf of respondent number 1, 3 and 5. Issue notice returnable in 4 weeks, since the learned departmental council has have appeared and accepted notice on behalf of all the respondents. No formal notice is required to be sent. In this case, extra copy of the writ petition be furnished to the departmental council office to list this case along with WPC sales.
The matter pertains to non-consideration of the, not providing approval of the district level selection committee of the present petitioner whose name has been recommended to the post of pump operator lordship. On the ground that the personnel, V department has issued a communication projecting that the promotion from personnel post is not being considered, your lordship. So far, my regularization has not been barred me from the purview of the promotion.
Will issue notice at this?
Yes, your lordship.
Mr. L. Mohan and the counsel for the petitioner. There is the amendments made in the writ petition. Agreed by non-consideration of their cases, will dismiss this writ petition ultimately, because promotion orders cannot be passed in joint writ petitions.
No, lordship is separate, because the minutes of the.
Now we are issuing notice.
Lordship.
We'll keep the maintainability open and dismiss it at the admission stage.
Lordship.
Yes, non-consideration of their cases for promotion.
Non-providing approval, lordship.
Huh?
Committee recommend, their case has already been recommended for promotion.
For refusing to grant approval to their cases for to the recommendations made in their favor for promotion to the respective post. Ms. M. Kalita, learned SCPHE, has raised question about maintainability of the writ petition due to misjoinder of parties. She, however, seeks 4 weeks time to obtain instruction and file affidavit. Prayer allowed, annulled 4 weeks, since Ms. Kalita has appeared and accepted notice on behalf of respondent numbers. All the respondents, no?
No, your lordship. 1, 2, 4, 5, 6, 7, 8.
1, 2, 4, 5, 6, 7, 8, and Ms. S. Burwa for respondent numbers 3. Respondent number 3, service of notice is deemed to be completing this case. Extra copies of the writ petition etc., etc. Question of maintainability of the writ petition is kept open and shall be gone into at the stage of admission hearing.
Right.
May it please your lordship. The petitioner before your lordship who is a differently able person with 50% locomotor disability has come before your lordship challenging the inaction of the respondents in not filling up the 69 vacant grade 4 posts reserved for persons with disability. And he belongs to the he is differently able. His disability certificate is at page 36, lordship, 50% locomotor disability, permanent disability in the elbow joint. He had responded to this.
All right, we'll issue notice at
Yes,
this stage,
lordship.
not Ms. B. Chaudhary, learned counsel appearing for the petitioner. The lead petitioner herein is a differently abled person with 50% locomotor disability, aggrieved by the inaction on the part of the state to fill up 69 vacant posts in the grade 4 category reserved for the persons with disability bracket PWD. This writ petition has been filed seeking a writ of mandamus. Mr. T.C. Chutia, learned additional senior government advocate Assam, prays for some time to obtain instruction in the matter. Issue notice of motion, returnable in 6 weeks. Since Mr. Chutia has appeared and accepted notice for the.
I am for 1 and 2 only, my lord.
1 and 2. Who else for rest? Ms. G. Vora for respond number 3. And what about 4, 5?
Like 4 lordship I am.
Who is for 4?
4, 5. 4, 5 I am.
If you know, could you go respond number 4?
Mr.
You are Miss ask for respond number 4. Mr.
number 7 and 8.
Mr. R.M. Das for respond numbers 5 and 6. And Mr.
Ahmed for 7 and 8.
Ahmed for respond number 7 and 8. Service of notice is being to be completed in this case. Extra copy of the writ petition be furnished to the learned department council requisite in numbers within a week from today. It is made clear that pendency of this writ petition shall not be a bar for the respondents to take appropriate steps in the matter in accordance with law if so advised.
This person we were appointed prior to 93. Similarly situated person, they have been regularized pursuant to government my lord policy. So I pray at this stage, my lord, I pray my lord, a notice payment.
Well, this part has been dealt with by Upendas, my lord. It has been rejected. They cannot be regularized, my lord. 1/4/1993. The police
Prior to 1/4.
Yes, it was prior to 1/4/1993. The policy decision was 22/7/2005. It was under consideration.
You want the matter to be dismissed?
My lord,
today?
no.
Notice. Yes. Mr. B.D. Das, senior counsel, elected by Mr. Richard Das, counsel for the petitioner.
17.
The writ petitioners herein claim to have been appointed as master roll workers prior to 1/4/1993, notwithstanding the same, their services have neither been regularized nor have they been paid the minimum scale of pay as provided.
Well, they are getting the scale pay. They are
We are
workers and
getting it.
What do you want? Regularization?
regulation.
Their services have not been regularized. As such, the instant writ petition has been filed seeking a writ of mandamus. Mr. B. Gogoi, learned standing counsel, health and family welfare.
No, here I appear for finance. Respondent 2.
Finance Department, Assam. That is the respondent number 2 submits that the petitioners are not entitled to the relief claimed in the writ petition. However, he has prayed for 4 weeks' time to obtain instruction and file an affidavit.
So this is like KAC, Cardiac Autonomous Council.
Record. In view of the above, NOM 6 weeks. Miss M. Kalika, Lanet, SCPHA, PS, accepts notice for respond numbers 1 and 3. And Miss H. S. Kemprai, Lanet, SCKAC, for respond numbers 4,
Copy
5 and 6. And service of notice will deemed to be complete in this case. Extra copy of the writ petition be furnished, etc. etc.
Please, your lordship, my lord, this matter relates to compassionate appointment, my lord. The petitioner had approved this honorable court earlier also, my lord. The last order is at page 21A, my lord.
Father died in 1999.
Brother, yes, my lord. He applied immediately after the death of his brother. My lord, his case was not considered, so he approved this honorable court in 2004, my lord. And there was the direction at page 21A, my lord.
2004, yes.
Yes, my lord.
Page
Page
21A.
21A, my lord. Fourth paragraph, my lord.
And then what has happened?
Then thereafter, my lord, since the passing of this order, communications are going on. Last communication is at page 34, my lord. That is dated 25th of April 2023, my lord. Page 34, my lord. Last page.
Still going on communication.
Yes, my lord.
It's time to stop the communication, won't you think?
But
So much of communication is not good. Father died in 1999.
99, my lord.
He's seeking compassionate appointment today.
My lord, he
We
sought
put an end to your client's agony round right now.
My lord, he applied in time, my lord.
Yes, but it's over now. Heard Miss S.B. Chaudhary, Learned Counsel, appearing for the petitioner also.
Your lordship may give a direction to
No,
complete
this
the
is,
process.
you are only prolonging his agony. He cannot get an appointment on compassionate ground in the year 2023 on account of death of his father, because the purpose of the scheme is to give immediate relief. Therefore, he cannot get it.
They may
Let us
reject,
put
my
it,
lord, at least they may consider, my lord, act upon this, my lord, of official communication.
No, we will not issue this kind of directions. This is creating problem for the whole system. These matters not permissible. Not
Here, the last line is the request to kindly submit a report on the matter of to this department for taking further necessary action.
Yes,
My lord, that is my lord, today to 23 years, my lord, after he has come for the compassionate appointment, my lord.
but why are your
The
people,
communication.
why is your officials
They are
communicating?
communicating is, my lord.
Ah.
I can, my lord, obtain instruction on only page 29. That was the, my lord, written by the Deputy Secretary, Government of Assam, to the Director General of, my lord, Civil Defense. My lord, directed them to place the matter.
All right.
to the-
So Mr. Chutia has put
Yes.
your client to ICU, but he is still surviving. 1 week's time to obtain instruction. Is S.B. Chaudhary, Learned Counsel for the petitioner. The father of the petitioner had died in the year.
Elder brother.
Elder brother of the petitioner had died in the year 1999, whereafter he had submitted an application seeking appointment on compassionate ground. The grievance of the petitioner is that his case has not been considered by the authorities till today. By pointing out the annexures to the petition, more particularly the communication dated 25/4/2023, issued by the Under Secretary to the Government of Assam Home and Political Department. Ms. Chaudhary submits that the matter is still under consideration by the department. As such, a writ of mandamus be issued by this court, granting relief to the petitioner. Mr. Chutia Learned, Additional Senior Government Advocate Assam, prays for a week's time to obtain instruction. Prayer allowed, 2 extra copies of the writ petition be furnished to Mr. Chutia. Let this matter be listed for motion again after a week.
Problem.
Item 14.
May I please? Well, this is my third round of litigation, my lord. Matter pertains to compassionate appointment. My name was recommended by the DLC, my lord, on 25/9/2017. Thereafter, no action has been taken for appointment. I have approached before this honorable court, my lord. Honorable court that
Your case was recommended when?
my lord, on 25/9/2017, my lord.
But by that time, the compassionate appointment scheme was withdrawn.
No, my lord, my case was on 18/9/2016, died on 18/9/2016.
That's right.
Yes.
But the scheme itself was withdrawn.
scheme was done on 2017, my lord, prior to that, my lord, my cases. Thereafter, my lord.
Yes, you obtained instruction, Ms. Kempai.
Yes, sir.
Heard Mr. D. Gogoi, learned counsel for the petitioner, agreed by non-consideration of his application for appointment on compassionate ground. The instant lead petition has been filed. This has complied, learned SCKC preparing for the respond numbers.
Two, two and three.
Who is appearing for
Oh,
4
yes,
and
yes,
5?
Lordship. 2, 3, 4.
You don't read the repetition before coming to the court.
Lordship. All the respondents are.
No.
2 to 7.
2 to 7, please for some time to obtain instruction in the matter. Issue notice of motion returnable in 6 weeks. Since Ms. M. Kalita, learned SCPHE has accepted notice for respond number 1 and Ms. Kemprai for respond numbers 2 to 7. Service of notice is deemed to be complete in this case. Extra copy of the repetition will be furnished to the learned department council within 7 days from today, so as to enable them to obtain instruction.
Item, please also send, my lord. Same here.
Same order, this with item 14.
Next report was this matter related with the selection and appointment of armed forces, different armed forces. And there is so many anomalies regarding selection matter. At this stage, notice matter. Only prayer matter, there are 6 petitioners, my lord. So many posts taken, my lord. So 6 posts may keep happening.
This is 2018 selection process.
Is a covered case.
No,
Yes,
but
covered.
covered, here the petitioners are not from OBC category.
All petitioners OBC here.
Hmm?
All petitioners OBC.
Where is the order? Earlier order? of this
Earlier
court?
order, my lord, page annexure 12, my lord. Annexure 12, page 234.
No, you don't have an order of this court, right?
This court.
No.
Order passed by Justice Suman Shah.
No.
Yeah, come up with the order, we'll pass it. Yes.
Public.
May I please, as a lordship? Lord, an order of transfer, my lord, is under challenge, my lord.
Where is the order?
My lord, may be pleased to find at page 52, my lord.
This order is passed more than 3 months back.
My lord,
More than 1 year.
my lord, 31/3/2022, my lord. That is correct, my lord. And thereafter, my lord, I have repeatedly approached the respondents, my lord. The bulkiness, my lord, of my repetition, most of my lord memorandum and representations, my lord. They have not at all, my lord, considered a single representation, my lord.
Where are you now? You
My
are,
lord, I am at Fakhruddin Ali Ahmed Medical College at Borpeta, my lord. My lord, only.
you have joined, you have
I
done.
have joined, I have joined. Join, and thereafter I have, my lord, prayed for the consideration because, my lord,
Which is the last representation?
my lord may be pleased to find is at page 96, my lord, annexure 20. That
So let them
Yes,
pass an order on it next,
yes,
within
yes,
next
yes,
6 weeks.
my lord, my lord.
Last representation, it will pay 100 to last.
No. My hearing, commission for this. Is to cannot. No, hearing minister, we have there for Nalaga. Commissioner is the best.
Page 96.
96.
Take down, heard Mr. Bhuya Lanet,
My-
counsel for the petitioner, also heard Mr. DP Bora Lanet, standing counsel, Health and Family Welfare Department, Assam, appearing for the respondents. The order of transfer dated 31/3/2022 bracket annexure 5 bracket close is under challenge in this writ petition. First up, by the impugned order dated 31/3/2022, the writ petitioner who was serving
Medical social.
as medical social
Worker.
worker posted at Silchar Medical College and Hospital at Silchar was transferred and posted in the same capacity in the Fakhruddin Ali Ahmed Medical College and Hospital. Vice Dr. Neelam Prasad Yadav, medical social worker. First up, Mr. Bhuya submits that being aggrieved by the transfer order, his client had submitted a number of representation. The last in the series being the representation dated no date 6/4/2023. However, the respondents have not considered the representation submitted by the petitioner till date. Mr. Bora submits that this order of transfer was passed more than a year back, and the petitioner has already joined at the FAAMCH at Borpeta pursuant to the impugned order of transfer. First up, the learned departmental council, however, has fairly agreed that the representation submitted by the petitioner deserves consideration at the hands of the appropriate authority. If that be so, by taking note of the facts and circumstances of the case and as agreed to by both the parties, this writ petition is being disposed of at the stage of motion hearing by providing that the respondent number, who is the respondent?
My lord, respondent number 1, my lord.
The respondent number 1 may examine the representation submitted by the petitioner on 6/4/2023 and pass appropriate order therein. Full stop. The exercise be carried out and completed within a period of 6 weeks from the date of receipt of a certified copy of this order, along with a copy of the representation dated 6/4/2023.
Private respondent may also be heard. Party may be affected.
Earlier submitted by the petitioner, it is made clear that it is needless to mention herein that before taking a decision in the matter, the respondent number 1 shall also consider
Respondent number 6.
the case of the respondent number 6.
My lord, one thing, respondent number 1, my lord, because he is commissioner and secretary of the Government of Assam Health and Family Welfare Department. Now he is under the Medical Education and Research Department. So the direction may be to the respondent number 2, my lord, Secretary Medical Education.
Respondent number 2, it is needless to mention here that before passing any final order, the respondent number 2 may also give an opportunity to the respondent number 6 to present her case. Writ petition stands disposed.
Highly obliged.
May I, Lordship, please? Lordship, with the moot question, the entire matter before your Lordship is whether the ration is included in the definition of the wages here. If the answer is no, then it touches the jurisdictional issue. My case is covered under the Supreme Court judgment. The ration is an amenity, an additional benefit not covered within the definition of the wages under the Minimum Wages Act, the 1991 Supreme Court. We are a TA state, your Lordship, that we in lieu of ration, we provided rupees 7 in cash. They said that you have to provide 14.20.
So what are you challenging here?
Then what happened, your Lordship, that the authority concerned pass an order, and thereafter they filed an application before the judicial CTM Kamrup Metro for recovery under section 15, subsection 5B, which is the recovery process. And the learned judicial magistrate issue is summoned to us. Now, our contention before this honorable court is that the wages is not covered Ration is not covered within the definition of wage. And that is covered by the Supreme Court judge.
Where is that?
Yes. Para 14. Para 14. May I read together?
Yes.
Para 14. The scheme of the Act is the Minimum Wages Act. Recognize wages as defined under Section 2H and also wages in kind. Under Section 11 of the Act. Reading both the provision together, wages in kind can only become a part of the wages if the condition provided under subsection 2, 3, and 4 of Section 11 of the Act are complied with. Admittedly, there was no notification by the central government under Section 11(3) of the Act, and as such, the supply of grain at a concessional rate cannot be considered wages under Section 2H of the Act. We may examine the question from another angle. The supply of grain at concessional rate to the workers is in the nature of an amenity or an additional facility service. The management, especially of public undertakings, are bound by the directive principle of the state policy, such and such, such and such. The workers must be ensured a living wages, just in human condition of work, and a decent standard of life. The management must endeavor to secure for the workmen, apart from the wages, other amenities like supply of essential commodities at concessional rates, medical aid, such and such. All these amenities may be capable of being expressed in terms of money. It is clear from the scheme of the Act that these concessions do not come within the definition of wages. As given under Section 2H of the Act, we have thus no hesitation in holding the supply of grain at a concessional rate to the workman is an amenity and cannot be included in the rates of wages prescribed by them.
Yes, what do you have to say?
So, my lord, the case is pending, but they are not cooperative, my lord. They are not cooperating, my lord. The notice was issued in all along, my lord, their absence. They can agitate it maybe before the district, my lord, the judicial magistrate court, my lord. They have page 73, lordship, page 73, 19.5.
So let the magistrate first consider this issue in the light of the judgment of Supreme Court and pass an order.
They can agitate it before this.
The problem lies with the magistrate, that he is limited, the magistrate is having a limited jurisdiction under the Act, only to recover, without going into the aspect of the jurisdictional issue or the other aspect of the matter. That is the whole issue. Otherwise, you have to move before the magistrate and raise all this issue.
But if the court directs, the magistrate cannot.
That's up to the honorable court.
They are not obeying, my lord. Earlier they were paying, my lord. Earlier they were paying due to COVID pandemic. They stop it for a time.
We're paying 7 till now, and
they admitted that they are paying.
Your lordship. Here before this honorable court, I am just raising one issue. There's 3 aspects. One is that we have an agreement with the workers, wherein we agreed to pay ₹7, which is continuing. And therefore, that agreement is binding upon all authorities under Section 18 of the ID Act.
You are paying ₹7 in lieu of grains.
Yes. And the authority demanded ₹15, 14.20. That is as per a general agreement with SEMA.
So then you seek a review before the labor, who has passed the original order?
Labor court.
Lordship will find at page 63. Order dated 31/5/2021.
63.
63. 63.
So you move the labor commissioner raising these issues and will pass him to pass a fresh order.
With the liberty to come before this honorable court.
They have also failed before this labor commission.
Until the matter is decided by the authority, the staircase may be stayed.
They are not cooperative. Page 64.
Mr. B. Dattal, Senior Counsel, assisted by Mr. S. Dakal, and Counsel appearing for the petitioner. I've also heard Mr. T.C. Chutia, learned additional senior government advocate Assam appearing for the respondent numbers
1, 2, and 3.
1, 2, and 3. First up. The writ petitioner hearing is the writ petitioner number 1 hearing is a writ petition number.
The partners of the Amchang TS
hearing are the partners of what is the name of the T state? It's not mentioned anywhere.
I'm saying, you know,
I'm sorry.
synopsis, in a synopsis of.
Synopsis, pages, I think, club one.
SCNS in short.
Second, para 2. Your worship.
Page 64, what
Yes,
is
give
relevant?
it me to writing, what is the name of it, is nowhere mentioned. What is this, Mr. Dekan? Huh?
Paragraph 2. Lordship. Paragraph 2 of the petition.
Tea estate commonly known as Amchang tea estate situated at Digaru district. Para 2. Your worship.
Are the partners of a firm owning a tea estate commonly known as Amsong Tea Estate situated at Digaru under Kamrup Metropolitan District, Assam. Assailing the order dated
We have challenged page 63 and as well as the proceeding before the judicial magistrate.
order dated
31/5/2021.
31/5/2021, bracket annexure 13, bracket close. Passed by the Assistant Labor Commissioner cum Authority under the Payment of Wages Act, Guwahati, in connection with LPW case number 06/2020, as well as the subsequent proceeding initiated before the magistrate
Page 71,
Kamrup
offense report.
in the form of CR case number 2593/2021 for enforcing the said order. The instant read petition has been filed. Full stop. Mr. Datta, learned senior counsel for the petitioner, has argued that as per a bilateral, as per the provisions of a bilateral agreement signed on 25/1/2021, the management of the tea estate is regularly paying a sum of ₹7 to the workers in lieu of ration. First up. Moreover, after the decision of the Supreme Court in the case of Manganese Ore bracket India bracket close limited versus Chandilal Shah and others reported in 1991 supplementary bracket 2 bracket close SSC 465. It is settled that ration cannot be included as part of wages. Notwithstanding the same, the learned Assistant Labor Commissioner has issued the direction for recovery of amount payable, recovery of additional amount payable as on account of ration from the management by ignoring the terms and conditions of the bilateral agreement dated 25/1/2021. First up, Mr. Datta has further argued that since ration cannot be treated as a part of wages, the learned Assistant Labor Commissioner did not have the jurisdiction to pass the impugned order dated so and so. Hence this writ petition. First up, Mr. T.C. Chutia, learned additional senior government advocate, on the other hand, has argued that the management of the tea estate had not cooperated in the proceeding, prompting the learned Labor Commissioner to issue the impugned order. First of, after hearing the submission of both the parties and on going through the material placed on record, I am of the view that since the issue raised by the petitioners goes into the root of this issue raised by the petitioner is a matter of jurisdiction that goes into the root of the matter, the learned assistant labor commissioner must consider the said aspect of the matter. As such, this writ petition is being disposed of with a direction upon the respondent number
Assistant Labor Commission.
to review the order dated
31/5/2021.
31/5/2021. If a review application is filed within 4 weeks from today filed by the petitioners within 4 weeks from today by enclosing a certified copy of this order. If the review petition is preferred within the above time frame, the same be considered with regard to the in the light of the observations made herein above, and a fresh order be passed in the matter until such time the aforesaid exercise is completed. Further proceeding in connection with CR case number 2593 of 2021 shall remain suspended. Writ petition.
Public.
Please, Your Lordship. This case is relating to compassionate appointment, Your Lordship. This case, Your Lordship, the district level committee, Your Lordship, page 61, recommended that.
Obtain instruction, heard Mr. Aram Chaudhary and counsel for the petition. There is the amendment made in the writ petition. NOM 66, Ms. MD Boral and Government Advocate Assam appears.
For all the respondent.
Notice for all the respondents, no formal notice, extra.
Deeply obliged.
No.
Item 20.
Make please, Your Lordship. My lord, by following due process of law or due process of selection procedures, these petitioners were selected for Anganwadi worker and their names were forwarded to the director by the CDPO, which is at page 55. 59, my lord.
55 or 59?
59, madam. Sorry, madam.
59, there is no name.
NHR 5, madam.
No name is there.
Later.
Madam. 55, the selection list, madam.
Where are the names?
Madam, 56, serial number 7, madam. So, and at 57 serial number 1, my lord, and 58 serial number 3, my lord.
So what has happened now?
My lord, thereafter, my lord, when the approval was sought by the CDPO from director, he directed the deputy commissioner for verification. There is no provision or guidelines or notification to that effect. Deputy commissioner cannot do that, my lord. And thereafter, my lord,
But Mr. Chief Marshal and counsel for the writ petitioners, the case of the petitioners is that although they were duly selected for appointment in the post of Anganwadi workers or
1 and 2 workers and the 3 is helper, my lord.
And their names were recommended. Approval of the same has not been granted by the Director of Social. Who has not granted approval?
Director, my lord.
By the Director, respondent number?
This one,
By the Director of Women and Child Development, Assam.
my lord.
On the ground that further verification is required in the matter. Agreed thereby, the instant writ petition has been filed.
My lord, there is one impugned order, my lord. By this order, he cancelled the entire selection process.
I will obtain instruction regarding why cancellation.
Additional.
There may be anomalies.
Assam prays for time till 23rd of June to seek instruction and appraise this court as to the basis on which the impugned order cancelling the select list has been issued. 2 extra copies of the petition be furnished to Mr. Chutia. List this case again on 23/6/2023 for motion.
Till such time, madam.
In such time what?
Stay,
Consideration
my
of-
lord.
So that they can be appointed.
No, my lord.
Then
This
No, there is a-
cancellation,
we have
otherwise,
what is there to be stayed here?
my lord,
Nothing.
let them bring. No. On that day, your lordship will consider.
Oh, yes.
Oblige.
May it please, Justice. Matter relating to compassionate appointment, my lord. Husband of the petition was died in 2010, my lord, and the proposal was submitted in 2013 by the respondent number 5 to the district level committee.
When was the application submitted?
My lord, it was submitted by lord 27/7/2010 within the time. It was within the.
You should obtain instruction, then we.
Yes, Lordship.
Heard Mr.
R. Islam.
R. Islam, Learned Counsel for the petition. Agreed by non-consideration of factors for appointment on compassionate ground. The petitioner is approached this court by filing the instant writ petition. Ms. S. Sharma, Learned Standing Counsel, Health and Family Welfare Department, Assam, as well as Ms. S. Barua, Learned Government Advocate, Assam, have both prayed for some time to obtain instruction. NOM 6 weeks since Ms. Sharma has appeared, Ms. Barua has accepted notice for respondent numbers. Cool. Acha, then you write Ms. Sharma for
1, 3, and 5, Lord.
1, 3, and 5, and Ms. Barua for respondent number
2 is for NHM, Lordship. B Gogoi name may be.
4. No formal notice is required to be sent in the to the said respondents. Likewise, Mr. B Gogoi, Learned Counsel, has appeared and accepted notice for respondent number 2. As such, service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the Learned Department Council. Let this matter be listed again after 6 weeks by reflecting the name of Learned Counsel for the respondent in the cause mystery.
Mass oblige.
Lord, I am appearing for the opposite party writ petitioner. My affidavit is being filed today, my lord. I tried to serve a copy, but there's some mistake in the one of the annexures. Just need to correct it and file it today. Could it be taken up, my lord, with the affidavit? Maybe Friday also, my lord. There's no difficulty.
Thursday.
Lordship.
Ms. B. Sharma, Learned Counsel, is present on behalf of the applicant. Mr. R. Majumdar, Learned Counsel, appearing for the OP writ petition, submits that the objection on behalf of his client is being filed during the course of the day. And therefore, this matter will be posted again on Thursday, course of the day. By expressing urgency in the matter, Ms. Sharma has sought posting of this matter again on 22/6/2023. Prayer allowed, registered to reach this case again on 22/6/2023 as a fixed item by taking the objection of the OP stroke writ petitioner with the record of this.
Obliged.
For admission, item 23.
But please allow.
May I please your lordship? Mr. Sharma is legs in code number 1. May kindly pass over the matter for the time being.
What is the matter?
My lord, here the petitioners have approached this honorable court seeking a direction for declaration of the recruitment results. The advertisement was issued in 2014 for recruitment of part-time, full-time sweepers in bank, Allahabad Bank. My lord, interviews were held, but results were not declared for a long time. And in 2018, they came before this honorable court saying that the results should be declared. Now, the bank had taken a stand that after the advertisement was issued, some changes were brought in by the ministry in the recruitment process. So they have kept the recruitment in abeyance. On that submission, my lord, the writ petition was disposed of. Now, we filed a review saying that the circular which they relied was issued after the advertisement and after the interview were held. So that circular could not have a retrospective effect on the recruitment process that was initiated in 2004. So the review was allowed. Lordship may have a look at the order passed on 10/4/2023 in the review petition. And the review was allowed and the matter has come before your lordship. The only question is in the advertisement, the process of selection was interview in 2014. In 2015, a circular was issued which says that recruitment by way of interview should be stopped and discontinued latest by 31/12/2015. So before the circular was issued, the interviews were held. Now the
But point is, can the court compel them to declare the results?
My lord, if your lordship takes up this 1990 judgment, it says that when an recruitment advertisement is held, then I have a right for fair consideration of the my candidature in terms of that advertisement. So they are relying on a circular which cannot have any effect.
That you are entitled to. But then can the court compel them to declare the results and go ahead with the recruitment process?
My lord, if they are relying on a circular to keep in abeyance the recruitment process, which is not applicable, definitely, my lord, they have to take the process of selection to its logical end.
Where is the law? Show me that law.
My lord, may have a 1990 3 SCC 157.
Have you given the book list?
Yes, my lord. My lord. 1990. I'm just marked the paragraph 11 and 13. And we have also decisions of our High Court. It says that if a rule is amended after the advertisement, then the amended rules will not have any retrospective effect unless it is made retrospective specifically.
So this judgment is on a point whether he has a right to be considered as per the terms and conditions of advertisement.
Yes.
But it says this is not an absolute right.
Yes, because here in the next paragraph, it says that if an rules are amended, my lord, where selection process is initiated by issuing an advertisement inviting application, that selection should be regulated by the rules which was in force at the time of issuance of the advertisement. Now, if the rule is
Mr. Chakraborty, perhaps it will be advisable you examine the law a little more and we have this matter after the vacation.
My lord,
prima facie, your argument difficult to accept.
my lord will appreciate one thing. They have issued an advertisement. They have on affidavit said that they have kept the advertisement.
What is the date of the advertisement?
My lord, the advertisement was issued on 30/11/2014. And the rules came in, or the circular was issued on, my lord, 31/12/2015, 22/12/2015. So on the date of the advertisement, lordship may have a look at the advertisement, which is at page 12.
So 2014 advertisement cannot be given effect to today. That's the law.
No, my lord.
Even if they want, they cannot.
No, my lord. They have initiated the process. Interviews were held. They have not declared the result and kept the process in abeyance. They have not cancelled it, my lord. It is the stand in the affidavit. They have not cancelled it. They have kept in abeyance because of this 2015 circular, which says that all interviews, process of selection by way of interview should be discontinued by 31/12/2015. So on 30/11/2014, the process was interview. The interview was directed to be stopped on up to 31/12/2015. before issuance of this guideline or circular, interviews were held. So the question which requires an answer, whether this circular will have any effect on the recruitment process which was initiated in 2014. If the answer is no, then as per the 2014 advertisement and the subsequent process taken, they have to declare the result.
Where is that law? I'm asking.
My lord, if
They may not like to go ahead with the process.
but they have to take, that is not their stand, my lord. Their stand is they have kept the process in abeyance. It is not their stand that they have cancelled the process. Their stand is they have kept the process in abeyance because of this circular. So if that circular does not apply, then the decision of the authority to keep the process in abeyance is irrational, my lord, is arbitrary. Because if they are supposed to act by following a particular process and they have stopped or kept the process in abeyance on certain circulars which is not applicable, then the process of their application or the process, decision-making process is
Where is
faulty, my
Mr. Sharma?
Code number 1.
Code
Lakes and
number
code
one,
number-
what? Which item?
Item number 20.
Call him, let him come up to some part. We'll see.
Or Lordship may take up at 2.
Two, we can't say. If the other matters are over, we will see. We'll do it.
Ma'am.
Wait, it may go to 2 also.
Much obliged. Item 25.
May I please, your lordship?
You are the newly engaged counsel.
Yes, my lord.
Yes.
My lord, matter pertains to recruitment in the post of sub-inspector in the Assam police.
Hmm.
My lord, the issue here is.
First of all, do you know the reason why a fresh counsel had to be?
Yes, my lord, I know that.
Then your apology has to come from the petitioner. otherwise
My lord?
you will not. A petitioner has to file an affidavit tendering apology.
He made an apology, my lord,
To whom?
before me, my lord. Otherwise, he will file an affidavit. my lord.
Let them file. On the request of Mr. B. Dekal and counsel for the petitioner, this matter stands adjourned for 2 weeks so as to enable the petitioner to file an additional affidavit. Mr. R. Majumdar and counsel for the.
Dibrugarh University.
Huh?
For the Dibrugarh University.
For the Dibrugarh University is present. You first file that affidavit.
Obliged.
Much obliged, my lord.
My lord, in this case, readings are complete. There is no interim order. It's a routine service matter. The issue is as to whether the absorption of the petitioner in the post of Deputy Director Training in Panchayat and Rural Development Department can be given retrospective effect. Usually, my lord, the law is that the order of absorption takes effect from the date on which the order of absorption is issued. Here, my lord, we would be pursuing your lordship to take a view that in the facts of this case, it ought to have been retrospective. It would need deliberation.
Let the persuasion come after the vacation.
Oh, yes, my lord. It would need deliberation. There are facts.
Mr. P. K. Tiwari, and a senior counsel appearing for the petitioner submits that this matter is ready as regards pleadings, and therefore it can be taken up for disposal at the stage of admission hearing. Mr. P. Nayak and Mr. S. Datta, Learned Department Counsel are present. On the request of Learned Counsel for both the sides, let this matter be listed in the second week of August 2023 on a non-miscellaneous day in the category of disposal at the stage of admission hearing. Unquote. To approach the Standard Chartered Bank seeking documentary evidence of the fact that the fixed deposit noted above was credited on maturity in the saving bank account of the deceased petitioner. If such a request is not acceded to in a time-bound manner, but needless to say, if such a request is not acceded to in a time-bound manner, the same would give rise to a fresh cause of action, which can be agitated by the legal heir of the petitioner by filing appropriate procedure. With the above observation, this writ petition stands closed.
Deep relief.
So you have got everything without.
In
putting
fact,
anything.
this is the relief I want.
Item 16, kindly consider.
What is
Item
16?
23. Item 29.
My lord, here in this case, my lord, affidavit by the government is necessary, my lord. I have agreed by the non-inviting me for the post of Kaupura.
Oh, they have not invited you.
My lord, we have not invited, although list, my name is in the list, but I have not invited in the list.
He has not fulfilled the criteria, Your Lordship.
Let them file affidavit.
No criteria, no invitation.
My lord.
All right, heard Mr. S. Line Council for the petitioner also heard Mr. S. Datta and his standing council Revenue Department Assam who prays for and is granted further.
Question number 1.
How much time to file affidavit?
2 weeks, Lordship.
Further 2 weeks time to file affidavit. Mr. J.K. Goswami, Learned Government Advocate Assam and Mr. A. Martin, Learned Council for the respond number are present. List the case accordingly.
Item 30.
May I please, Your Lord? Not.
Yes.
Instruction I see.
Yes, please.
Lordship, the petitioner was temporarily appointed as Paras cleaner under Industrial Tribunal, Lordship, Guwahati, in the year 2008, Lordship.
So you want more time?
Lordship.
They have not been able to trace out the files. This says Kanungo Learned Council for the petitioner is present. Mr. J.K. Goswami, Learned Government Advocate Assam has produced a copy of the communication dated 15/5/2023 received from the government with a request to grant 4 weeks time for filing affidavit as the relevant file has gone untraceable. Stop. You are for?
5 and 6, my lord.
Mr. H.K. Das, Learned Council for respond numbers 5 and 6, and Mr. P. Nayak, Learned FC Finance Attorney for respond number 2 are present. On the request of Mr. Goswami, these matters stands adjourned for 4 weeks so as to enable him to file application.
Item 31.
May I please? Similar orders can be passed, OBC candidate. Similar orders are passed by this court.
Yes.
My lord, I'm, yes, qualified, my lord. Computer based examination, physical test, physical eligibility, all.
OBC,
Lordship.
Mr. S. Sohan, and this side, Mr. S.S. Roy. Rest is same, disposed of. Disposed of.
Much obliged. Matter relates to sexual harassment to women at workplace, my lord. Internal complaint committee was not there. After lodging complaint, my lord, when the matter was referred to the police station, then only internal complaint committee was constituted.
So now the committee is there.
Now it is there.
It has been instituted, Your Lordship, and the committee has taken cognizance of the matter, and notice has been issued to the complainant to come and record her statement. So the
Let the
process is
committee
already
take a
under.
decision within 3 months.
Lordship.
But actually, there is a mandatory provision to take decision, but to submit report within 90 days from the date of receipt of the complaint. As per section 9, my lord.
Section 9 of.
Section 9 of Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013.
Section 9.
Section 9, my lord.
When was the complaint lodged?
Complaint was lodged on, my lord.
I may appeal yourselves. In this case, my lord, though the DLC recommended the name of the petitioner as a junior assistant, my lord, page 40, my lord. Page 40, my lord.
Page 40.
Yes, my lord, decided applicant Ashraful, my lord. Ashraful Hussain, Islam, my lord. Page 40, my lord. But state level committee, my lord, did not place the name in the state level committee, my lord. On the grounded, my lord, force fathers had less than 3 years service, my lord. As per the notification, my lord, 1/5/2015, my lord. Clause 1, my lord. That clause was set aside by the judgment, my lord.
Yes. We have filed appeal and delay condolation petition has filed. In this case, we have filed our appeal on delay. Yes,
Once that is, any order is passed, then we'll see. Third, Mr. A. Matin, when did the father die?
Father died, my lord,
Mr. A. Matin,
12/6/2015.
petitioner. The petitioner's father, who was serving as senior assistant under the amalgamated establishment of Deputy Commissioner, Bongaigaon, had died in harness on 12/6/2015. Full stop. Since he was the sole bread earner of the family, hence the petitioner, being the son, had submitted application for compassionate appointment on 29/6/2015, which was duly recommended by the DLC of Bongaigaon. In terms of the resolution adopted in meeting dated,
Page 40, my lord.
what is the date of the meeting?
Yes, my lord. Yes, yes. Page 39, my lord.
You still can't say what is the date of the resolution.
Date, my lord, 23/6/2022. Top, my lord. 23/6/2022.
23/6/2022. However, the said recommendation has not been considered by the SLC, apparently on account of the fact that the father of the petitioner did not have more than 3 years of service to his credit at the time of his demise, and in view of clause 15 of the OM dated 1/6/2015, such an application was liable to be rejected on such count alone. First of Mr. Matin, however, submits that by the judgment and order dated 30/1/2023, passed by the learned single judge in WPC number
WPC number 1646/2021 and other.
1646 of the 2021, clause 15 of OM dated 1/6/2015 has been struck down by holding the same unconstitutional. Ms. Borua, learned government advocate Assam. S. Borua, learned government advocate Assam, appearing for the respondents, however, submit that the state has preferred an appeal against the judgment and order dated 30/1/2023, passed by the learned single judge. The learned government advocate has, however, fairly submitted that no interim order has been passed by the division bench suspending the operation of the aforesaid judgment. If that be so, the SLC would be duty bound to consider the recommendation of the DLC and pass appropriate order and take appropriate decision on the application submitted by the petitioner. The said process has evidently not been completed in this case. As such, this writ petition stands disposed of with the direction upon the essence to consider the recommendation dated so and so made by the DLC Bongaigaon, who are the writ petitioner, and take appropriate decision in the matter. Whatever be the decision, the same be communicated to the petitioner within a period of 3 months thereafter. With the above observation, writ petition stands closed.
Okay.
Order dated 12/6/2023 make kindly visible. That serious board employees, my lord, they were sought to be transferred to, handed over to the Silchar Municipal Board. And now they are not getting their salaries from June 21. In fact, my lord, I was told, my lord, they are, although all work has been done, they are continuing their service in Sewerage Board only. My lord, I am just pointing out this. But no salary has been paid. All decision has been taken to transfer it. Paperwork has been done as they got their transfer. They went to Silchar Municipal Board. They are not allowed to work, so therefore they came back. All the documents have been handed over to the Silchar Municipal Board, but they are not paying their salary. Nobody is saying, my lord. From June 21, 34 employees.
Yes, Mr.
The government was directed to obtain instruction.
Lordship, here this is suitable, come here is in.
No, we'll pass an order right now. Yes. Take down hard, Mr. V.D. Das, Leonard Senior Counsel at the assistant.
Lordship will take note of one document only, Lordship, at page 107, Lordship.
Yes.
This is a letter written by the Urban Water Sewerage Board, Lordship, pursuant to government's decision. And this is the actual handing over, Lordship.
No, Mr. Nayak, they want salary.
Yes, Lordship. That is
Who
what
is
I'm.
going to pay the salary?
That salary portion only, Lordship. One paragraph, second page, Lordship, 107A. In view of above government order, the man and materials along with liabilities of Silchar Water Supply Scheme has handed over to Silchar Municipal Board. The amount of revenue already collected in account of Managing Director, Assam Urban Water Sewerage Board amounting to 8,90,000 only be credited to the account of Silchar Municipal Board bearing number so and so. So along with the person, this is not the only Silchar Municipal Board, Lordship. Same thing happened in case of all municipal boards, Lordship. And along with Lordship, this amount was sent to the account of the Silchar Municipal Board, Lordship.
Thereafter?
Now that amount is presently with the Silchar Municipal Board. Lord, they should clarify what happened to this amount, Lordship.
But this is really unacceptable.
I understand the anxiety of the petitioner, Lordship. Their only concern is the salary. Lordship. But who will pay the salary, Lordship? That question will be.
Let the Chief Secretary pass an order clarifying this matter. We are not getting involved in this. Yes, what has happened to the amount?
For 8 months, municipal board has paid, but then no fund is forthcoming. They haven't paid after.
Who is to give the fund to the municipal?
Well, this Sewerage Board, they will have to pay it. They have to collect the fund and give it to us. Otherwise, unless the fund comes from the municipality's fund, it is difficult to pay. With the understanding was that only.
Who is appearing for Sewerage Board?
Mr. Chaudhary is there.
What about the fund?
Lordship, what happened, the instruction that I received, pursuant to that instruction, was the one-page instruction. I'm just
just narrating this particular aspect of the matter. The matter was discussed in the 61st board meeting of the directors meeting held on 24/2/2023. Agenda item number 1. It is resolved that the honorable chairman, vice chairman and managing director should discuss regarding handing over of various water supply schemes to ULB in light of present status of revenue accrual to the board and draw up suitable state ground for revival of the board by reverting back all the schemes already handed over to concerned municipal board. The process of handing over is going on as per the earlier government order. The process of handing over the scheme is to concerned municipal board who are willing to take over is awaited due to Honorable Guwahati High Court interim order dated such and such of the case number WBC number such and such for the order. So there is a pending writ petition before this honorable court
Which
lordship.
is the pending writ petition?
This writ petition number is 7586 of 2022.
There is some interim order.
To others, Malad, not us. We are willing to go, Malad. We are abiding by the court's board's order. Some persons are not abiding by the board's order. They don't want to abide by.
All right, what is the case number?
7586 of 2022 lordship.
7586 of 2000.
2022.
We'll have it on Thursday along with
Yes,
that, Mr. Das. Heard so and so for the petitioner. Also heard learned counsel appearing for the respondents. It has been pointed out that due to an interim order operating in another writ petition being WBC number 7586 of 2022, there is some problem coming in the way of smooth handing over of the schemes from the urban water supply sewerage board to the municipal board, full stop. In view of the aforesaid stand taken by Mr. S.P. Chaudhary, Learned Standing Council, AUWS and SB, registry to list this case along with WPC number 7586 of 2022. Again, when do you want? Wednesday or Thursday?
Let it be on Wednesday, Malad, because I will not be there after Wednesday. For some reason. Let it be on Wednesday.
Then Monday?
Next Monday, Malad, I will not be there, Malad. I will on vacation on Thursday.
You will not be there, but the order will not come on Wednesday.
Thursday.
This is Thursday or Friday?
Thursday, not Friday.
Monday, next Monday.
Let it be Thursday.
Always.
Well, in item 35, Lordship, on behalf of respondent number 2, 3, and 4, I have entered appearance recently, Malad. I pray for 2 weeks' time, Malad, for filing the affidavit, Malad.
Yes, what do you say?
Lordship.
Mr. R.K. Talukdar, Learned Counsel for the petitioners, present. Mr. D. Nath, Learned Counsel, who has entered appearance on behalf of respondent numbers 2, 3, and 4.
2, 3, 4, 5.
Praise for how much time?
2 weeks' time.
2 weeks' time to obtain instruction and file affidavit. Prayer allowed. You are not for one.
No, my colleague will appear.
One.
The government advocate Assam is not appearing for the
No,
state of
no,
Assam.
Malad, she is appearing, Malad. She is appearing.
This is Burwa Learned Government Advocate Assam.
For 1, 1, 6, and
And
others.
Mr. MC Brown.
But if it doesn't
M.
exist,
Smith. Learned Counsel is present on behalf of respondent number 10. So you are for 1,
6, 7, 8, 9.
7, 8, 9. On the request of Mr. Nath, this matter stands adjourned for 2 weeks.
May I please, Lordship, matter pertaining to appointment and completion of ground, my lord. Petitioner name has been recommended by the DLC, my lord, page 28, my lord. Serial number 8, my lord.
He was not under the establishment of Excise Department, Your Lordship. He was under the amalgamated establishment of the Deputy
Died in
Commissioner.
harness on 26/5/2004,
My lord,
19 years back.
my lord. But it has been recommended by on my lord 10/10/2022 only, my lord.
How you are recommending applications after 15 years, 12 years? Heard Ms. S. Shukla, Learned Counsel for the petitioner, also heard Ms. M. Kalita, Learned Standing Counsel, Excise Department, also, who has produced a copy of the order dated, communication dated 16/6/2023 to submit that the petitioner's father was not an employee of the Excise Department, but he was serving under the amalgamated establishment of Deputy Commissioner Dharam. As such, the prayer made by the petitioner cannot be considered by the Excise Department. First of all, Ms. S. Burwal, government advocate, has on praise for 4 weeks time to obtain instruction in the matter. This court has also noticed that the application submitted by the petitioner on 14/6/2004 was considered and recommended by the DLC only in the year 2021, thereby
22, my lord.
2020,
22, my lord.
thereby giving an impression that the question of delay in consideration of applications for appointment on compassionate ground is not being consistently dealt with by the respective authorities. Ms. Borua to also obtain instruction and address this court on the aforesaid aspect of the matter. List again after vacation.
Timely matters item 16.
You are appearing in this case. You have a printout of the same order of this court. Is it covered by the earlier judgments?
Yes, Lordship, covered.
Heard Mr. H.K. Bulshul, Learned Counsel for the petitioners. Also heard Ms. S. Borua, Learned CGC, appearing for the respondents. Disposed of. Give a copy of the order. It's similar. Hmm.
23.
The same matter, he has not yet come.
No.
We'll allow it if it doesn't come at 2.
Well,
For admission supplementary, it's item 22.
Last occasion directed the advocate for respondent number 7, my lord. Right.
Today morning, my lord, I have received one affidavit, my lord. Filed by the respondent number 7.
we have filed our affidavit, my lord, for respondent number 7, my lord, I appear for the university. Now, my lord, initially, when the first time the mark sheets were sent to us, only the pass certificate was sent to us. And since there was a transition from the Sanskrit board to the university, the records with the university did not show the petitioner to be a past candidate. He was shown to be a failed candidate. That record was given to the CISF authorities. Later on, my lord, petitioner again approached the Sanskrit board, the then Sanskrit board, my lord, and he got all the documents transmitted to the university. There it was found that he had passed on a re-examination. And therefore, the second certificate saying that he has passed on a re-examination. Fact remains, my lord, petitioner had passed the examination on re-examination.
So then he was dismissed from service.
He was dismissed from service based on our first letter.
That is not correct then.
That is not, that dismissal perhaps is not correct. Now, my lord, I find that he has filed an appeal to the DIG. If he files a comprehensive appeal to the DIG of the CISF, saying that this is the stand taken by the university in their affidavit in the writ petition, the DIG can well reinstate him, my lord.
What has the DIG got to do now?
My lord, he will be on appeal, my lord. The commandant
He has to be reinstated because
He
it
has
was
to
a
be
notice. So we'll pass that order.
Would do this, Mayor. His Lordship, my lord, I have annexed the copy of the later dated 31/8/2021 in my affidavit, my lord.
Is
Yeah,
your
he
affidavit
has
on
his,
record?
Record, my lord.
Affidavit,
Yeah,
who has
fine.
filed affidavit this morning?
I have.
So that is not on record.
Yes, I have also filed.
Then we'll have it on Monday with the affidavits and disclosure. Heard Mr. M. Borbuya, learned counsel for the petitioner, also heard Mr. A.K. Datta, learned CGC appearing for the respondent numbers 1 to 6, and Mr. R. Majumdar, learned counsel appearing for the respondent number 7. It appears that the respondent number 7 has filed an affidavit this morning, which is not on record. Considering the importance of this said affidavit in the matter, the registry is directed to tag the affidavit in the record of this case and list this matter again on Monday, that is 26th of June 2023 as a fixed item.
Please, your lordship. A petitioner is died, your lordship, and his legal heirs were not unable to contact his legal heirs.
Which is the, what is the order? Where is the order of the court? You take the, heard Mr. Your name, please?
A. Hussain, your lordship.
A. Hussain, learned counsel for the petitioner.
On behalf of Andhar, sir.
This contempt case has been filed alleging willful disobedience of the order dated 3/10/2013 passed by this court in WPC number 2877 of 2016. 2006, by means of which a direction was issued. 2006, whereby a direction was issued to the respondents to examine the case of the petitioner and thereafter reinstate the petitioner in service and pay all his back wages with effect from 2012-2005. Full stop. Mr. Hussain submits that during the pendency of this proceeding, the petitioner has expired and he is unable to establish contact with the legal heirs of the petitioner. Be that as it may, insofar as the prayer for reinstatement of the petitioner is concerned, the order for reinstatement of the petitioner is concerned, the said order cannot be implemented if the petitioner has expired. First up, the direction to pay back wages would only be a consequential relief which would be permissible after the petitioner is subjected to examination by a medical board, which is also not possible at this stage. Full stop. As such, this contempt case is hereby closed by granting liberty to the legal heirs of the petitioner to pursue appropriate legal remedy in the matter so advised.
All right.
Item 38.
This contempt case has been filed alleging willful disobedience of the order dated 27/5/2015, passed in WPC number 1408 of 2015. None appears for the petitioner. On call, the petitioner's counsel was absent even on the previous occasion. Having regard to the nature of direction issued by this court, it appears that no live issue survives in this case at this point of time. As such, this contempt case stands closed by granting liberty to the petitioner to avail appropriate remedy as may be permissible under the law if he continues to remain aggrieved in the matter.
Item 39 to 41.
My lord, in fact, my lord, I am not aware of the present status of the case, my lord. In the meantime, my lord, contender perhaps will not retire from service. So we need to, my lord, substitute the present incumbent. Otherwise, my lord, the contempt still survives. No. Because, my lord.
You are for whom? The contempt petitioner or opposite parties?
I am contempt petitioner.
So what is the, you don't want the order of the court to be implemented?
Yes, my lord.
What is the date of the order?
Date of the order is, my lord.
It's 8/9, my lord. 8/9/2014 was the first order for directing the government to consider, creation of posts. My lord, show cause on 16th of February 2016. And if your lordship will take it up, take the next item number 40. And otherwise,
So why three contempt cases?
Hello, there are, my lord, three different.
three orders. Actually, the first order is 8/9/2014. Similar two orders are passed. One was 22 and 24 of the same month. Same year. So if your lordship will kindly see the show cause notice, my lord, filed by the contender number 1, my lord, on 15/2/2016.
Yes, page number?
Page number, my lord, the compliance order is at page number 7, annexure 1 of the show cause. I'm sorry, my lord, if it is paginated and that I have not. They should have written.
So you are referring to the show cause reply.
My lord. By contender number 1, my lord, who was the then chief secretary. He is retired now.
Yes.
Now, page 7, if my lord can come to annexure 1.
Yes.
The relevant portion is, my lord, at page 10, internal page 10. In fact, my lord, if just can point out one thing. There were only, my lord, 383 posts, sanctioned posts, against which the BTC authority appointed 2,366 persons. So those who were on regular, appointed on regular posts, they were given, my lord, their services were regularized. But those who were not on the regular post, they were given some fixed pay. And therefore, the court says that you consider creation of posts, because we had by then, it is a word in the order itself that we have received application from the BTC, proposal from BTC to create these number of posts, 22,366 posts. So the court, the Honorable Court member said, you consider this. And then we considered an internal page 10, if my lord will kindly see. The third paragraph, in the present case, the existence of the need of creation of posts for regularization of illegally appointed fixed pay employees of BTC is relevant factor. Considering the relevant aspect mentioned above, the decision for creation of posts for such huge number of employees appointed without authority, without posts with huge financial implication for the state cannot be taken on any rational consideration.
All right, so we'll close this matter. They've already passed. Yes, Mr. Pukasto, you challenge this
rejected.
order.
This order can be
Or
challenged.
Mr. A.K. Pukasto, Learning Council appearing for the petitioner. Contempt cases in all these, contempt petitioners in all these contempt cases. Also heard Mr. D.K. Mishra and his senior counsel listed by Mr. D.K. Prasad and it
For contender number 1.
for the contemptor number 1, who submits that by the order dated 8/10/2015 passed by his client, the order of this court has been complied with. I peruse the order dated 8/10/2015, which goes to show that after due consideration of the directions passed by this court, by order dated so and so, so and so, and so and so in WPC, you'll get it in page number 7, huh? Just see the directions. You get it all. The matter was duly considered whereafter an order was passed. The order dated 8/10/2015 is not under challenge in any proceeding before this court. If that is so, since the direction of the learned single judge was to consider the possibilities of creation of post, and that direction has been duly considered by the respondent number 1, whereafter necessary order has been passed, it cannot be said that the order of this court has not been complied with. In view of the above, all these 3 contempt cases stand closed by granting liberty to the contempt petitioners to avail appropriate remedy as may be permissible under the law. It's a vice. Yes.
My lord, I am appealing for item number 1441.
Achha, AK Purgasto in item
Item number 39.
39 and 40 and 41, Miss R.S. Devi. Yes, what is your?
My senior is suffering from fever, lordship. Kindly
On
make
the
a
prayer of
adjourn for.
Petitioners Council, these matters stand adjourned and shall now be listed after the summer vacation. Yes. None appears for the petitioner on call. This contempt case was instituted in the year 2017, alleging willful disobedience of the order dated 24/2/2016 passed in WPC number 21 of 2016, whereby a direction was issued by the learned single judge to place the case of the petitioner before the DLC for consideration of his application for appointment on compassionate ground, full stop. It appears that the father of the petitioner died in harness on 08/01/2012. Whereafter he had submitted an application seeking appointment on compassionate ground on 28/3/2012. It is evident that more than 11 years have passed since the father of the petitioner has expired. As such, it is the element of compassion appears to have been lost in this case, for which reason the petitioner has apparently lost interest in pursuing this matter before this court. As such, this contempt case stands closed.
Item 45.
Lordship, an affidavit was filed by respondent number 1, Lordship, on 18/12/2019, Lordship. Matter was pertaining to compassionate appointment, Lordship.
So what has happened? Order has not been complied with.
Lordship may see the affidavit, Lordship. Page 2, Lordship. Sanjay Krishna, Kumar Sanjay Krishna.
Against that, I have filed a reply, my lord.
Lordship may see, Lordship.
So it is matter has to be heard. or
Yes, my
something?
lord, it should be heard.
All right.
Because I have
Mr.
filed
C.
reply.
Borua, learned counsel for the petitioner, and Mr. M. Bhagavati, learned counsel appearing to the respondents, submit that pleadings are complete in this case, and therefore this matter will be posted again after this summer vacation for
Right.
disposal.
My lord.
They are allowed to list the case accordingly. Next matter.
Hello.
Achha.
The affidavit is read by someone.
My lord, that matter, my lord, where the director appeared, today he was supposed to file one affidavit, a comprehensive affidavit indicating, my lord, all the contempt cases which are pending against the directorate. I pray for some further time, my lord, we'll file it by another 1 week, month. Or after vacation, in the meantime, we can place certain, my lord, updated instruction in all the cases.
Mr. B. Gogoi, learned counsel for the respondent is present. Dr. Neil Madhav, the Director of Health Service, Assam, is also present personally in terms of the order dated 29/5/2023 passed by this court. A request has, Mr. N. Bora, learned counsel, has appeared for the petitioner. Mr. Gogoi has requested 4 weeks further time to file the comprehensive affidavit in terms of the order passed by this court. Full stop. What about the petitioner?
Petitioner, my lord, I am received by petitioner receive on the gratuity and area pension. Other
Regarding
DIS,
regular
GPF,
petition, my lord,
leave
he has been
application.
instructed by the treasury as well as the joint director to approach the treasury officer. There is certain, my lord, formalities. Let him approach, my lord, he will get that regular pension too. Otherwise, provisional pension he is enjoying.
Mr. Bora, learned counsel for the petitioner, submits that his client has already received gratuity
No, gratuity and area pension.
and arrear pension.
But GIS, GPF, leave encashment and regular pension are not received.
But GIF,
GIS,
GIS.
GPF,
GPF,
leave encashment
leave encashment
and regular pension.
and regular pension has not been received by him. Mr. Gogoi has responded by submitting that the petitioner must approach the treasury officer to sign certain documents, whereafter the amounts due to him will be released. Taking note of the above submission and the request made by Mr. Gogoi, this matter is directed to be posted again on 26th of July 2023 as a fixed item, so as to enable the respondent to file the comprehensive affidavit. The respondent is so and so Director Health Services shall remain present personally again on the next date fixed.
Regarding, my lord, that on his appearance before the treasury officer, he will get the regular pension, my lord. He will draw the pension, not the other benefits, my lord. That will take some time. my lord.
Signing certain documents, the petitioner would get the
Regular pension. Yes, my lord.
Monitored.
May I please your lordship? Lordship, it's a contempt application for violation of the Honorable Court's order dated 15/2/2022.
So issue notice 8 weeks. Miss, your name please?
M. Chakravarti.
M. Chakravarti, 8 weeks.
Matter passes, my lord, non-compliance, my lord,
8
judgment. My lord. Available.
May I please listen, in the contempt file for non-compliance order dated 10/2023.
In this case, I am paying for some time to file affidavit, not
Miss, your
the
name
final
please?
stage
A.N.
of
Hussain.
preparation. madam.
And
A.N. Hussain.
is A.N. Hussain is present on behalf of the petitioner. Mr. R. Dubey, learned counsel, appearing for respondent numbers 1 to 8, prays for and is granted
Lordship,
further
there
2
is
weeks
an
time
interim order, interim protection.
to file affidavit. Let the matter be listed again after summer vacation. Interim order passed earlier to continue. Only one matter is present. Okay.
My lord may come to page 12, the advertisement.
Why have you not published the outcome? Take a decision. You can't keep it pending since 2014.
Yes, your lordship. This has been discontinued, your lordship, by the Ministry of Finance. That is
What has been discontinued?
at page number 43 of my affidavit in opposition, your lordship.
What has been discontinued?
That the process of interview, your lordship.
So you have abandoned it.
No, your lordship, till date, no decision has been taken, your lordship.
Then you go ahead with it.
Because after, your lordship, may kindly refer one point only this.
Mr. Sharma, either you go ahead with it or you show me where you have abandoned it. There is no third alternative.
But your lordship, ministry has given in direction in such a manner that we are not in a position to move in.
What is the direction?
That is
Page 7
page
of the
44, your lordship.
Page 44.
Yes, your lordship.
44
Of my affidavit in opposition. Continuous page. That is, therefore, in the last three lines, sorry, your lordship, it has been decided that the third line, your lordship, it has been decided that the decision to discontinue the interview in recruitment process of PSBs for the post of sub-staffs and clerks, while letter of even number dated 22/12/2015 have been arrived at the Cabinet Secretary DOPT level. Therefore, the bank which are not in agreement with the decision may approach for relaxation with full justification through this department to the DOPT. And thereafter, one IBA letter is also at page number 45. So all the most it has been discontinued, your lordship.
Where have you stated that?
Yes, sir.
Where have you stated that?
Yes, in my affidavit, it has been stated that it
Where-
has been
where?
kept in abeyance, your lordship. In page
That is
number-
what they agreed with. They say you can't keep it in abeyance for eternity.
Yes, your lordship.
Well,
So, Mr. Chakraborty, we'll ask them to take a decision and notify it. If they decide to go ahead with the matter, they will go ahead. If they abandon it, that decision you can challenge. At the moment, that cause of action is not here.
my lord, for a moment, if your lordship takes up, because this is the affidavit filed, page number 7, which is the original decision of the ministry. This is
Mr. Chakraborty, if we are seeking an order asking them to go ahead with the interview process, that order I am not.
My lord, interview is already over.
No, one is pending, your lordship.
Interview is already over. Lordship will, for a moment, lordship, just have a look. Page number 7. It has not been discontinued. Lordship will have a look at page number
So, Mr.
7.
Chakraborty, all I am saying is, let them take a final decision and notify it. Before that, on presumptions and assumptions, there can't be a mandamus issue.
My lord, they are relying on this government circular. If that government circular says that that process has been discontinued, for a moment, my lord, lordship will bear with me, my lord. Now it says, I am directed. This is a letter of Ministry of Finance, 22 December 2015.
You are referring to?
My lord, my copy that is served with me.
It is page number
7.
44, your lordship. It is
Not
page
page
number
number
44. your lordship. Continuous page number.
No,
44.
it is not page number 54.
My affidavit, it is 7, but it is continuous page number 44.
Page number 43. Page number 43. December 22, 2015. I am directed to refer to the announcement made by the Honorable PM in his address to the nation on the occasion of Independence Day on the subject cited above, and to say the Committee of Secretaries chaired by the Cabinet Secretary in its meeting held on 13/11/2015 has recommended discontinuation of interviews in the recruitment process in public sector banks for junior level posts by the deadline of 31/12/2015. So, my lord, if I have understood the meaning, the up to 31/12/2015, whatever you have done, but after 31/12/2015, no selection by way of interview. So they have been directed to discontinue after 31/12/2015. My lord, the advertisement was issued on, my lord, 30/11/2014. Lordship will find the advertisement at page 12. And interviews were held prior to coming into this letter. So the question which comes for consideration before a lordship, before issuance of this circular prohibiting the process of interview post 31/12/2015, whether the interview advertisement and the interview held prior to this can be kept in abeyance by relying on this circular. Because this circular is prospective, it will be effective post 31/12/2015. Now, my lord, may have a look at their affidavit. They have not stated that they have discontinued. They have stated, based on this 22/12/2015 circular, they have kept the process in abeyance. Now, if that circular does not apply to the recruitment process, the process which was initiated prior to the coming of this circular, whether that reliance on the circular and to keep the decision pending
process pending will be a valid decision in the eye of law, my lord. Because this circular cannot have,
It will not. That's why we are asking them to take a decision and notify.
my lord. But if
The
this,
more,
if
the
your
time
lord,
you consume.
my lord, if your lordship directs that or declares that this circular will not have operative effect in that recruitment process and that should take a call without being influenced by the circular, then my lord, everything will be over. My lord.
That cannot be done. You can ask for anything, but we will not do it. Because there is no decision as on date whether they will go by the circular or they will not go. They are just sitting quiet. We can ask them that you cannot continue to sit quiet because there is a right which is accrued on these people who have appeared to know the outcome of the process. That is how the legal process moves.
Yes,
Mr. Chakravarti.
But my
Today
lord,
itself, you can't get a direction that.
or my lord, I'll just indicate two decisions which say that a circular or change in the rules, which is not indicated that it will operate retrospectively, it will always operate
Mr.
prospectively.
Chakravarti, the problem is you are putting the cart before the horse. These are issues which cannot be gone into by the court today. The court will only take note of the fact that they have been sitting quiet. Let them take a decision. They have not decided that this applies to them. On what basis can we say that even if they decide, they cannot decide?
No, my
Their
lord,
decision cannot
what
be
I
of
have
this.
understood from the affidavit, they have taken a call that this is the circular and
Where
because
is
of
the
this.
statement in your affidavit?
Yes, sir. Paragraph 9. And the fact that they had conducted the interview has also been suppressed in the writ petition, my lord, in the affidavit. It is only when we filed the review, it has come to light that interviews were already over.
Your lordship, one is pending on that. Is in paragraph 9, last part, your lordship. All the recruitment process of full part-time sweeper was kept in abeyance till further instructions.
So my lord, they are awaiting instruction from the department with regard to this circular. If this circular prima facie does not apply, then my lord, that instruction seeking instructions perhaps my lord will further delay the process. My lord.
And your lordship in the.
Mr. Chakravarti, what I didn't want to say is your writ petition is not maintainable. You have not implicated the Union of India as a party.
My lord, that time.
Yes, yes.
My lord, that time,
Maintainable.
bank was a.
Yes, you realize it, no?
My lord, I was lawyer, I was not a lawyer that time.
Whoever, it's nothing personal about you.
My lord.
Let this order be passed. If it still does not solve your person, you have to come to the court for the second time. There is no way out. The direction you are seeking cannot be passed. Do I need to be more categorical about than this? The issue, publish the list and make appointments that order.
No, we are not on appointment, my lord. Our prayer is.
They will have to first decide what they want to do with it, with reasons to be recorded. That reason is justifiable. Till the reason is given, the court cannot make any observation on that. So the problem is this matter has been pending since 5 years.
My lord.
If that order was taken 4 years back,
2014.
by now your clients would have known where they are standing today.
My lord, it was disposed of on, my lord, earlier on a different line and then on 3/6/2022. Then we filed a review. We brought in record that the interviews were held and this honorable court, while allowing the review petition, had decided that it needs to be reheard.
What is the order you are seeking today?
I am seeking, my lord, first for your lordship to decide whether that 22/12/2015 circular will.
Mr. So, let this matter be listed before any other bench without me. Yes, I've already expressed my opinion. I can't go into that. Yes, please, next matter. Yes, part 2. Some other bench without me. You try it. That order is not possible.
My lord, item 23 in the part 2,
Yes.
this matter we are not pressing. 23.
23.
Yes, the matter, there's a writ petition against an award. My lord, the parties have settled it. That instruction I have.
Take down item 23, Mr. Who's there for the other side?
My lord, for the management, I do not know, it's a long matter. We are not. pressing-
Mr. S. Chakravarti, learned counsel for the petitioner submits that after the award was passed, the parties have amicably
During pendency of the writ petition.
settled the matter during the pendency of this writ petition, and therefore he has instructions not to press this writ petition any further. Taking note of the submission made by Mr. Chakravarti, this writ petition stands disposed of as not pressed. Is there any interim order?
No,
Disposed
the
of is
writ
not
petition filed by the workman.
pressed. Right. Disposed of is not pressed.
Item 2 and 3.
Lordship here, the petitioners, my lord. Uh, in terms of the employment notice, my lord, this advertisement, my lord, page 18.
Yeah, who's for the department here?
Treasury office, government.
Sorry?
Finance. Chief Secretary is there, Deputy Commissioner, Additional Deputy Director Accounts, Treasury Officer, Commissioner.
So are you appearing in this case, Mr.?
Yes, my lord, I will appear. I am for 1, 2, and 3, my lord. Deputy
So what is your stand?
My lord, there is my lord, problem is.
Hmm? Yes, so
Junior
tell-
accounts assistant.
what is the law? How could this be have been cancelled at the instance of minister?
Yes.
My handicap, my lord, I don't have the file, my lord, today. One instant.
That is this case. There was an advertisement notice issued for filling up 10 vacant post of junior accounts assistant and 1 grade 4 post. They participated and the select list was ready. After that, the process has been cancelled and an order has been issued to float fresh advertisement, which has been stayed by this court in the present proceeding. So his case is that there was no basis for the cancellation of the earlier process, which was initiated in the year 2007.
My lord, why it is cancelled, my lord, not known to me, my lord.
You are, how will we know?
I don't have file, my lord, I haven't seen anything. Let it be tomorrow, otherwise, my lord, I will see second file.
Tomorrow?
As your lordship.
All right, tomorrow then you go through the file, court's file, tomorrow.
Item 4.
So any matter where both sides are ready?
In my matter, Mr. Das is appearing for the other side. We've been waiting for last few.
What is the matter about?
Sir, this is against an award of the Learned Labor Court. Hey, he doesn't get
How long will it take?
about 30 minutes or so, my lord. Because the issue is otherwise very short here. You have to-
Because if it is a long matter, then we'll hear today, but post it again after vacation.
Very well. Then I leave it to your lordship, maybe after vacation.
Because
we'll do it.
I'm traveling.
My
in
lord,
2
then
days'
let
time.
us do it
And
after
I
the
won't have
vacation.
time to deliver the judgment.
Very well, my lord. Then
There are
because
other matters which have been
ultimately
asked.
your lordship will have to see the evidence also a little bit, because here the Learned Labor Court has said that the inquiry is proper, but set aside the award saying that the inquiry finding of the inquiry officer is perverse. Your lordship knows that the inquiry normally
11A.
11A. Normally the
Why don't you wait till vacation?
Very
There's
well,
a
very-
judgment coming on 11A from this court.
very well, my lord.
There is some judgment is being authored.
My lord. Here, otherwise, my lord, this issue is well settled from Ritz Theatre in 63. Your lordship knows it, my lord.
Which are the decisions given?
My lord, I am going to rely on Ritz Theatre, which is of 63. If your lordships recollect, the law is settled in this manner. In the cases of dismissal matters, there are options given to the management because the management holds an inquiry. Now, here the option is that the management can rely on the inquiry. If the management relies on the inquiry, at first the labor court has to try that as a preliminary issue and see whether the inquiry is proper, valid or not. Now, if a finding comes that the inquiry is not valid or the findings are perverse, then the management has an opportunity to adduce fresh evidence in the labor court. Thereafter, the labor court will on its own look into the merit and comes to a finding. This is how, right? It started from
Which is
Ritz
the judgment?
Theatre.
Which is the
My lord,
judgment?
I'll give it to your lordships. We have got photocopies also. Ritz Theatre is AIR 1963 Supreme Court 295. This is Ritz Theatre. My junior will give the list and the.
Can you give the citation?
Yes, AIR 1963 Supreme Court 295. And after Ritz Theatre, there is Delhi Cloth House where the principles were laid down, which is AIR 1972 Supreme Court 1031. Here, the options have been given that the management, while appearing before the labor court,
Which are the relevant paragraphs?
my lord, in Ritz Theatre, the paragraph would be 8, 9, and 8 to 14. In Delhi Cloth House, paragraph 19, 20, 24, 43, 44, 45, 46, 48, and the principles are at paragraph 61. And then your lordship knows 11A was amended. After the amendment, Firestone case came, which says Ritz Theatre, the decision that was given in Ritz Theatre still holds the faith. Firestone is AIR 1973 Supreme Court 1227. A last case to Justice Sapre. And the paragraphs are 30, 31, 32, 33, 34, and 44. Because 11A says now materials in record will have to be taken. Now that the Firestone have explained, that means everything, including fresh evidence, if adduced before the learned tribunal. And the last one we checked is of Justice Sapre, which is 2018, volume 18 SSC, page 21. Here also they say, right, paragraph 35 says Ritz Theatre and all these decisions are the decisions which holds good, my lord, the principles laid down there. So paragraph 35, 39, 43, and 46. Interesting. This is 2018, volume 18 SSC, page 21. The entire thing is covered here, my lord. It's beautifully explained in all these cases. The only difference that came after insertion of amendment of 11A is that now the labor court, it finds that the punishment is not proportionate, can take a different view. And earlier what happens during Ritz Theatre and all those cases, it was as a matter of caution, they say the labor court should not look into reappreciate or appreciate the evidence before the inquiry officer. That part there has been a little change and second, no, the labor court can see if it is totally perverse, can set aside that and then look into the additional evidence. But this additional evidence has to be given by the management. The management has to exercise that discretion, either at the time of filing the pleadings or at the time when it is held at the preliminary inquiry.
So you meant to say that, say, if a workman
Yes, my lord.
is dismissed from service pursuant to a domestic inquiry, and there is a reference registered raising an industrial dispute, the labor court will first have to examine and come to a conclusion that the inquiry report and the consequential order was not passed in a just and fair and reasonable manner. Having come to that conclusion, then the labor court will have to look into evidence to arrive at its own satisfaction as to whether the facts were sufficient to.
Absolutely. They can examine the merits on their own. They get
Therefore,
that.
unless the first part is done,
Yes.
second part
Will not come in. Will not come. So there are decisions where they look everything together in the very first place. So then the Supreme Court says, okay, no, that is wrong. Because first you examine the validity. Only when you come to a finding that it is not valid.
Which is that decision where Supreme Court says first you examine the validity.
Well, Lord, if I'm not wrong, I had to read something, Nikhil. Well, I'll give it to her because I think it's Nita Kalpesh. I will just give it to your lordships. 99 Nita Kalpesh, no? I'll just check that because yesterday only I read that. Most likely it is 1999 volume 1 SSC 517. But I'll check that. If your lordship is wanting that part, I'll give it to. There is a decision saying that. And in fact, in Britannica's case, it has been clarified because many times the attack is that the labor court has to suo moto give this opportunity. There also the Supreme Court says, no, it is an option which the management has to take it. So either at the time when they file their pleadings before the labor court or at the time of when the validity is in question, they exercise that option and say, no, if this goes against us, then we'll adduce the evidence or simultaneously adduce it with their pleadings. Then, of course, the labor court have to follow this exercise. But if that is not done on its own, the labor court, there is no obligation for the labor court. Now I have hold the inquiry invalid, therefore you come and give us evidence. That exercise the labor court need not do. This is something which is for the management to take it. And when the management exercise that option, then the labor court will give a similar right to the workman side also.
All right.
Deeply obliged. I'll point out that decision.
So we'll do it after vacation then. Let the judgment come, you examine it. Any other matter where both sides? Yes.